Good morning, everyone. This is the Judiciary Committee Non-Civil. We've got 3 bills on the agenda. Let me ask everyone to please turn off your cell phones or put them on vibrate. Now, the first bill we'll call is House Bill 303, Chairman Rogers, excuse me.
Thank you. Thank you, Mr. Chairman. Members of the committee, I bring to you House Bill 303. House Bill 303, the information was brought to me by the Solicitor Generals of the state of Georgia and my Solicitor General from Gainesville, Hall County, Stephanie Woodard. Simply allows the solicitors to be able to get information, access to information as far as DFACS is concerned. And that's simply what it does. Has not been any opposition so far. Be glad to try to answer any questions.
As I understand it, Chairman Rogers and Solicitor, thank you so much for being here.
Thank you for having me.
The first thing I thought of this morning on this particular bill was talk, just if you could illustrate it for us from an operational standpoint, in order to be able to, the ability to access these records when you're taking a look at a potential charge in a particular fact situation. How is looking at this material relevant to the decisions you make on a particular charge?
What it is allow, quite often DFACS is the first responder in a situation where law enforcement has responded to where a typical situation we have is a child endangerment or reckless conduct where a child's been left alone. There's no actual injury, so it ends up a misdemeanor instead of a felony. DFACS worker has already spoken with the child. It allows us to look without currently, since we're not under the statute, I have to file an order. I file a motion, have the judge issue an order for them to let me look at it. But I can see what the child said to, what the facts that were given to the DFACS worker without having to re-interview the child, without having to have contact that might in any way traumatize them again. It gives me the information that was provided at that time. Not that I would have to stop there in preparation if we have to go to trial, but it just keeps the amount of time that the child has to be re-interviewed. Currently, this is information that's available to district attorneys simply upon request. They are enumerated under the statute. Solicitor Generals at the misdemeanor level are not, and this just brings our prosecution office to the same level of the district attorney.
Mr. Collins.
Thank you, Mr. Chairman. I'll be recognized for a motion at the appropriate time.
Will do, Mr. Knox.
Thank you, Mr. Chairman. What are the situations where the state court would need this information?
What we have are predominantly, I see in my office, are reckless conduct charges. Currently, I have 2 cases. One's where 3 children, ages 2, 9, and 11, were left unattended from 11 p.m. till 11 a.m. It was discovered when the kids were out in the road trying to cross the road to get to neighbors for food. There was no actual injury, so the charge is a misdemeanor. I want to see, 1, what the children said in their initial interview, not to have to speak to them again. Misdemeanors, we aren't assigned an investigator, crimes against persons, like they would be if it were a felony charge where the child was actually hurt. So it keeps me from having to use additional expensive personnel to go out and interview the child. It reduces impact to the child. Lets me see what happened. Lets me see if the parents are in compliance with DFACS, if they're participating in therapeutic recommendations, if they're complying with the juvenile court judge, which will also be taken into prosecutorial consideration for me in the seriousness, one, of whether to pursue a criminal charge, what level of accusation to level, and what to look at for disposition in any kind of sentence.
Would that be subject to discovery by the defense as well then?
Not currently.
When you say not currently, it's not currently because they can't get the DFACS file.
No, not under the current nature of the discovery laws, no. And I want to see any statements that I then take would be, but not when we review the DFACS records, and especially under the state of the misdemeanor discovery.
Don't we have an issue about whether that violates the discovery rules then?
Well, 1, no, sir, not under the misdemeanor discovery statutes. And 2, that's not... 1, the defendant is their client, and they have access to their copies of the DFACS records. Any parenting plan, anything that DFACS enters into with the defendant, they have a copy of themselves, and that's available to their attorney. It's not available to the state.
Thank you, Mr. Chairman.
Yes, sir. Any further questions for Chairman Rogers or his solicitor? Thank you, sir. Is there any other party in the audience who would like to speak on this bill? Yea or nay? Seeing none, there's a motion on the floor from Mr. Collins. Is there a second? Any further discussion? Any amendments? Ms. Travis.
Just the question of two things. One, the question of the effective date.
Mm-hmm.
If you all want to add it.
Yep.
And our general language.
You're still not on.
Oh, I'm sorry.
When we're trying to rid the code of district attorney unless we have to use district attorney, and I can see why we do need to use district attorney here. Possibly, we generally use prosecuting attorney because that covers DAs, ADAs, solicitors, assistant solicitors. So, if you wanted to, you could say the district attorney of any judicial circuit in this state or any prosecuting attorney who may seek such access in connection with official duty. It's a little shorter.
Under the language as we have it right now.
It's fine. It's just a little wordy, and like I said, we're our general shift when we're drafting is to say prosecuting attorney, unless, like, there's certain things that only district attorneys can do, but really that's small.
Mr. Knox.
They have, but I mean, they have different jurisdictions, don't they? I mean, prosecuting attorney. I'm not even. Is it defined in the code at all?
No, sir.
Okay, so but it's for drafting convenience.
Well, it's because the powers of them two are so similar. Like, prosecutors can issue subpoenas. Prosecuting attorneys have duties of discovery in the felony actions, and we call them prosecuting attorneys there. If you did a search of the code, you'd understand. I'm not trying to put a kink in it here. I'm just, if y'all are interested.
For purposes of consistency and uniformity, would we do better to err on the side of caution in preserving the language in terms of uniformity and consistency in the code as it stands right now?
You know, I don't have that code section in front of me to know if district attorney is referred to elsewhere. I'm assuming if it was anywhere else in that code section, there would have been commensurate changes if we gave any powers to the assistant solicitor.
I think out of an abundance of caution, I'd like to go ahead and keep the language the way it is, and if maybe that could be explored on the other side. It's a technical.
It's not a huge
It's a
deal.
technical issue. In terms
Just
of
the effective date.
In terms of effective date, I would recommend the governor's signature. Any objection? Hearing none, I'll just go ahead and offer that as amendment, and hearing no objection will be adopted as effective date. The effective date will be the governor's signature. Any further amendments? Hearing none, there's a motion by Mr. Collins, a second by... I'm sorry. Mr. Everson, I'm sorry. Any further discussion? All in favor say aye.
Aye.
Opposed? The ayes have it. Motion passes. Thank you, Chairman Rogers, for your patience. House Bill 123, Chairman Ramsey.
Mr. Chairman.
Yes, sir.
While we're switching off, I'd like to recognize that I have also a Superior Court judge here today. Miss Judge Kathy Goslin is here from
Where is
the
she?
Northeastern Circuit right there.
Judge, thank you so much for being here.
Recognized?
Yes, sir.
Thank you, Mr. Chairman and members of the committee. Those that were here for the subcommittee hearing on this bill, I introduced my district attorney, Scott Ballard. I'd like to do so again. He's joining me up here. The issue that I'm seeking to address here came to light in connection with a case he was prosecuting back in 2008. I guess it was a 2007 case. And he's really been helpful throughout this entire process, and I wanted him to come up here and help me answer some questions as we move through this. I have a substitute we've gone in a little bit different direction from what we did in subcommittee, and I'm going to talk about the differences, but I want to talk a little bit about the problem I'm seeking to address first. What we're trying to address here is a problem that was created in the court case back in the mid-'90s, the State versus Vines case. And what happened was it was a situation where the State was prosecuting an individual who, by telephone, prosecuting an individual for child molestation, who by telephone had contacted a minor and was having had a series of lewd conversations. I'm not sure if it's helpful or not, but I have copies of the case if everybody wants to look. And what the court did, and I think it's helpful since we're talking about the definition of child molestation to read the definition to kind of put everything in context here. OCGA 16-6-4 provides that the crime of child molestation is committed when a person does any immoral or indecent act to, or in the presence of, or with any child under the age of 16 years with the intent to arouse or satisfy the sexual desires of either the child or the person. What the court did in Vines is they ultimately overturned the conviction and said, in reading that definition, they said you have to be physically present, that the victim and the accused have to be physically present with one another in order to be convicted for child molestation. Now, that hasn't really been a problem until very recently, because there's not a lot of situations where the State is trying to prosecute somebody for committing child molestation for contact over the telephone. But now, with the proliferation of webcams, internet contact, now we have this physical presence requirement out there. And if an individual, and kind of, I'll give you an example, kind of the bizarre result of this case ruling right now, because of this physical presence requirement that the Supreme Court, the majority of the Supreme Court, read into the law, you can have two individuals use identical words to induce a child to watch an identical act, a lewd act, and one can be prosecuted for child molestation if the child's in the same room with the individual. The other cannot be convicted of child molestation because it's being done over a webcam, even though the impacts on the child are exactly the same. So I think the case probably would have come out differently had they known where technology was going. When they read something like this into the law, I guess it's hard to look into the future. But I think it's really created a problem. And what brought this to my attention was a case, State v. Self, that Mr. Ballard prosecuted. In a portion of that case, it was actually not a child; it was an internet sting with our local police down in Peachtree City. And a portion of the conviction was overturned. It was a webcam situation where the offender thought he was communicating with a child over a webcam, was committed a lewd act, induced what he thought was the child to watch him do a lewd act over the webcam. To that portion of the portion of the conviction that invoked the child molestation statute was ultimately overturned, and the court said, while we find the argument compelling, the policy argument compelling, we're bound by the Supreme Court case. We see no distinction between contact via telephone and contact via webcam, and the physical presence requirement has us force us to throw that part of the conviction out. So I think it's both a matter of statutory construction and just the policy they created. I think the court got it wrong, and Justice Hines in his dissent, his kind of summation of all this is far more articulate than I could ever be. And I just want to read an excerpt from his dissent in that Vines case. He said, "The plain language of the statute renders it unnecessary that the child victim be in the perpetrator's presence in order for molestation to occur. The crime is committed when the perpetrator, with the intent to arouse or satisfy his or her own sexual desires or those of the child, does an immoral or indecent act in one of three ways: to a child, in the presence of a child, or with a child. To declare that the statute does not criminalize the conduct unless the perpetrator is in the child's presence would be to ignore two of the ways in which the legislature has declared the crime can be committed. When the legislature uses the disjunctive or, it must be so construed unless there's a clear indication otherwise. By the specific terms of OCGA 16-6-4, if the perpetrator performs an immoral or indecent act to or with a child with the requisite intent, the crime is committed regardless of present." That's the only reasonable reading of the statute. I couldn't agree with Justice Hines more strongly. So I'm going to talk a little bit about what we did with the substitute. I've been working on this over the course of several months, and originally the way we were going with this, we were going to try to put a definition for the word presence, and that's what we did in subcommittee. We defined what presence was, and we said presence could also include contact via a variety of electronic means, trying to find the best way to get this physical presence requirement out of the law while also not spiraling off some unintended consequences. So that's what we had in subcommittee. After a lot of consultation with a lot of folks, and I want to thank Representative Abrams and Chairman Golick and the Prosecuting Attorneys Council and Sandy Michael, we've all really been working hard on this. I think Sandy would cringe every time she saw me coming around the corner the last week because she thought I had a new version of this substitute. But what we've done now is there was concern with what we did in subcommittee by some in the Prosecuting Attorneys Council that by dealing with the definition in the existing child molestation statute, we might unsettle some law somewhere else that we can't think of. So we thought, let's try to get at the conduct we're trying to get at and set off a second paragraph and not disturb the existing and try to define a word in the existing child molestation statute. So that's the substitute you have before you. So what we've done is we're adding a subparagraph 2, and we say, by means of an electronic device, such person transmit images, text, or audio of any immoral or indecent act to a child under the age of 16 years with the intent to arouse or satisfy the sexual desires of either the child or the person. We've tried to make it track with the definition in paragraph 1, and I think after a lot of hard work, we've gotten to the point where we've thought of every possible scenario and every unintended consequence. I think we've gotten to the point we've got a good piece of legislation here that addresses what we want it to address without unsettling law somewhere else that we just can't think of. So with that, I'm gonna see if my friend and District Attorney Scott Ballard wants to make any comments, and then I'm happy to yield for any questions from the committee.
Thank you for the opportunity to be here. For quite some time now, this body, the Georgia General Assembly, has a well-deserved national reputation as champions for children. The opponents are fighting back, though. They have a potential atom bomb now, perverts I'm talking about, and that's the Internet. Our children are more vulnerable than they've ever been because of the Internet. It's a wonderful tool, but it can also be a very dangerous thing for our children. We all know that. This bill is just intended to take what was already illegal to do in the actual presence of a child and make it equally illegal to do it if you do it by webcam. What the facts of the Self case was that this guy who thought he was talking to a 15-year-old girl masturbated and ejaculated over webcam so that it was visible. If that had been done in the physical, actual presence of the child, that's child molestation because he did a lewd act in the presence of a child. If it had actually been a child that he was doing in front of, it was an undercover agent in this particular case. Under this bill, if it was actually a child watching on the webcam, that would be child molestation, and we could treat this person who is a child molester for what he actually is.
Thank you, Mr. Ballard. Questions from members of the committee for our witnesses, for Mr. Ramsey and Mr. Ballard. Learn how to count these things. Mr. Sessler.
Thank you, Mr. Chairman. Appreciate you coming out today. Just to try to for me, as I listen to this, I'm just trying to think through, as Representative Ramsey said, this kind of thread in the needle where we don't bring in unintended consequences versus trying to address what needs to be addressed. How would this be prosecuted today, given the lewd act that you described over the Internet? What tools do prosecutors have to address that? What would the charge be under their current law?
There may be a way to address this under I don't know the exact code section, but the obscene Internet contact provision.
Is it 1612.100.2? Is that right?
That's right.
All right. That's what.
But if this actually become law and we were to prosecute this as a child molestation, we would need the child probably to testify that this is what I saw on the webcam, and then we would trace the the transmission back to the actual computer where it originated, and that would be the way it would be prosecuted.
What's the current sentencing and penalty framework for child molestation?
1 to 20.
1 to 20.
5 to 20.
Is it 5 to 20?
It graduates up per offense. In order
That's
to
right. That's right.
What is and again, I've got a couple more questions. My only concern as I look at this is by means of electronic device transmits images, text, or audio. I mean, what you've described in terms of a webcam starts to, in my mind, approach someone standing there next to a child. I guess the concern I have is, as you look at this, if you transmit something, I mean, this would seem to mean if you transmitted a pornographic image to a person or to a group of persons. I mean, say there was an image that is considered to be indecent. I mean, and we could widely discuss what indecent is.
Sure.
I mean, I was in the grocery store the other night, and I walked by the Sports Illustrated swimsuit edition, and I looked at it, and I thought, that would have been on the cover of Sports Illustrated in 1965. I don't know that the definition of indecent, immoral, is that clearly defined.
What? Is that a question?
Well, I'm kind of circling back to a question. My concern is, and I'd like you, either the author or the witness to address it. When we talk about transmitting images over the internet, a picture of a person with a topless female, for example, might be an indecent image. If that is transmitted out to a group of 10 people on an internet over an email, and one of the people that opens the image is a 14-year-old, that to me is, I've transmitted an image to a 15-year-old, which triggers a 5 to 20-year felony sentence. I want to understand. I understand what we're trying to get to. I guess my concern is the way it's worded. I just have some real hesitancy.
Well, remember that we still have to prove that the intention of the actor was to arouse the sexual desires of either himself or the person to whom he's transmitting the image.
And it has to be, per the language, it has to be transmitted to a child under the age of 16. And you asked about immoral or indecent act. That's the language that's in the child molestation that has been on the books for many years. There's volumes and volumes of cases that get at what's an immoral or indecent act.
Well, again, so I take back, and I don't think this is an absurd situation. Let's say that there's a 19-year-old boy that has topless pictures of women, or women that may be even more objectionable than that, and he transmits them to 13, 14-year-old brothers, some junior high brothers or siblings or whatever, that were clearly to arouse their sexual interests. Hey, check this out, blah, 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 transmitted to them. I mean, that to me triggers the definition of child molestation. He's transmitting images that are indecent. He's transmitting them to minors, and it's to induce their sexual interest. Again, I don't think any of us would expect what I've just described to meet the definition of child molestation. I'm just real concerned. I'm concerned with the language I read on the paper here, what effect it's going to have.
The best way I would think you should approach this bill is to imagine that the act you're describing being done over the internet, imagine that it was done actually in the room with those 13-year-old children. And the question then would be, is the 19-year-old doing a lewd act in the presence of a person under 16 with the intent to arouse the sexual desires of either himself or of the child by bringing these topless women into the room? The answer to that question, who knows? It's going to depend on your jury to some extent. It's going to depend on the more able community, perhaps. But that's the same situation we have with the law as it now exists. And as Representative Ramsey said, you've got a well-developed case law addressing those types of matters. This is just an opportunity to close a loophole that molesters know exists.
I understand, and I don't oppose your intent, please. Right. Understand. I'm just concerned. We're talking a 5 to 20 year felony. We're talking about, and as is so frequently said in this building, we vote on words on a page, sure. And I think when we define the elements of this, I think it's got to be very clearly done, Mr. Chairman.
Mr. Levitas.
What I hope is a friendly question. I remember whether it was child molestation or some other crime, there was an issue about if the transmission comes from out of state, and we had to add some language to make it clear that it was where the image was received. Do we need that here or not?
I think that might be a good, if I may, ask Mr. Olson from the Prosecuting Attorney's Council.
Could I ask Mr. Levitas to repeat that question?
Yeah, I'm sorry. The question was, I don't remember exactly what the crime was, but I know there was an issue a year or two ago, maybe more, where we had to amend a bill or amend a law to say that it's where the image was received, so that if someone was out of state, and I'm just wondering, do we need that here, or is that already covered in some kind of general code section? Okay.
Mr. Lunsford.
Mr. Chairman, thank you. Actually, great minds think alike. Had to do with establishing jurisdiction where the crime was committed. We did that in telephone language a couple of years ago on telephones for obscene calls and stuff to 911 operators. And so we could find the language for that pretty simply, and it was in House Bill 394, I think, was the language the solicitors came up to establish the exact jurisdiction to where it was received at. But I had a couple other questions, Mr. Chairman, if I could.
Yes, please.
On line 14, we start off by means of an electronic device. Would we not be better served if we used the word any instead of an? And the reason I say that is technology is changing every single day. What you and I carry as BlackBerries today, 6 years ago, 7 years ago, did not exist. And tomorrow you'll be talking on Skype telephones, which didn't exist 1 year ago. And they don't even use the exact same technology that we currently use today. Well, they're operating on Wi-Fi and broadband. So if we change it to any, I think we may not have to revisit the code section for a while.
Well, that's a good point. We actually talked a lot. We wanted, by using that term electronic device, we wanted to
I figured you were open telephones too.
Well, we were trying to stay out of the way of evolving technology and give it and leave it as broad as possible. But by making it any rather than an, if the representative believes that
I'm asking the question for the wisdom of this committee. It may help us revisit. I had a couple other questions, Mr. Chairman, if I could go on. I had a question about your terminology of transmits. And the reason I say that, and this may seem like I'm chasing rabbits, but it's pretty clear. U.S. copyright laws, as far as downloading video, for instance, if you download a movie illegally to your laptop and burn it, you've infringed on U.S. copyright laws. If you actually go on a website that is posted in China or Japan and watch it on their website, you haven't violated the copyright laws. So instead of saying transmits, if there's no true definition of Georgia code, if we use the word posts or transmits, then if they actually posted to what you would consider to be a basically it's like a stagnant site, and you could actually send your videos there and they reroute back to you, or that child could view them there. You never transmitted to that child. Mm-hmm. You posted it and they viewed it.
This is another
just difference in technology.
That word transmit. We had several words and we went around and around on this issue, but what we were trying to avoid, and I'm concerned post might cause the problem we were trying to avoid, is the person that posts an image, or the person that sends an image or broadcasts an image that is not intended for the child, not intended for the person under the age of 16, but maybe they're sending it to another adult, and the child intercepts the email, or the child happens on to the web posting, if you use the word post, and that opens up the door for somebody to prosecute somebody that wasn't intending to actually transmit to the child. We felt like the word transmit provided for an action of actually sending something to the child intentionally, and we were trying to avoid the situation as I described.
If I could follow up, Mr. Chairman, I think you already roped them in anyway. When you look at line 15 and 16 together, basically you're saying if I submit the image or transmit the image to arouse satisfy sexual desires of either the child or the person.
Right.
So if I'm the person sending them and I arouse the desires of a child unintendedly, and I aroused my desires during the process, you already got me anyway.
Well, but if you here's the scenario. If you
because
if
there are people that just flash people. That
right.
doesn't do anything for the recipient. I assure you. I'm sure.
But because it's either the sexual desires of the child or the person. What the reading we were concerned about is the person sends an email to another adult to arouse their own sexual desires.
Correct.
The child intercepts it. It was never intended to go to the child, and they're able to prosecute that person for child molestation. We felt like the use of the word transmit, again, evokes an action where they're actually sending it to the child intentionally versus we originally had the word broadcast. We had a list of words. We had the word broadcast in there, for instance, or otherwise communicates, and we wanted to make very clear that it was an act intentioned to reach the child.
Yeah, the posting really goes to intent because you don't have the requisite intent there, as I see it.
Right, and I'm just asking a question, Mr. Chairman, and then I've got one more follow-up, if I could.
Sure.
I'm just looking for the wisdom of the committee. It's a different twist for you, Mr. Ballard.
Yes, sir.
I have some concerns, as most of you all know. I have several children, 7. However, most of them aren't children anymore, but that's a flock, a covey, I guess, of hawks, right?
You could have your own reality TV show.
I have my own reality TV show, almost like the Duggarts. But anyway, I have some concerns with the proliferation of the Internet and false advertising, deceptive advertising. I use special software in every computer in my home and every computer I own to keep my children from going places I don't want them to go. I think it's a responsible thing to do as a parent. However, you can falsely advertise a game. Come view the new Game Boy game, and when that kid clicks that spot, if you don't have software, he's going somewhere you never intended for him to go. And many times it's going to be out of state and we don't have jurisdiction. If we can establish jurisdiction that the offense occurred where it was viewed, we get jurisdiction. So have you thought about, or by any electronic device deceives a child by deceptive advertising, which proposes to attract the child to view something moral that becomes an immoral act, or something to that effect? So if we deceive them into going to a website that's not supposed to be immoral, and all of a sudden you route them into a live porn cam, they've just committed it. Now, the person, unfortunately, on the other end of the camera doesn't know who just clicked in, but the person who created the website does. And I don't know how to address it, and this may not be the vehicle, but maybe something to think about in the future.
Yeah, our goal in this subparagraph 2 was to make it mirror the existing definition of child molestation as much as possible. And I
understand, Mr. Ramsey. It's just a room of broken toys, and you're here.
Yeah. Yes, sir.
But in all seriousness, Representative Lunsford is touching on some areas that are going to be the brave new world of criminal appellate work in the next generation.
Yeah.
And it's just a promise. And we'll be seeing more of that as the years go on. There's no doubt about it. Ms. Abrams and then Mr. Knox. Oh,
please.
Very well. Yes, ma'am.
I think most of them have been addressed, but just to follow up with some of the questions. Mr. Ramsey, isn't it true that the way this is drafted, it's designed to be, I mean, certainly to Mr. Setzler's concerns, it's designed to be as narrowly tailored as possible so that we explore the new world of, the new frontier of electronic devices without becoming overly expansive, and that more importantly, there will be no acts that are currently captured under this law that aren't currently captured under the existing law.
Right. Yeah. The goal is the act that is committed is to be evaluated in the context of all the case law that's out there right now evaluating acts of the accused. We just want to give a context in which the act that's communicated via electronic means can be evaluated for child molestation as well.
And if I can follow up.
Yes, ma'am.
Just to use the example that Mr. Setzler provided, if a 19-year-old were to walk into a room with several copies of lewd magazines and show them to 13-year-old boys, that the intent would have to be something that the district attorney would have to determine qualifies as, number one, a felony case of child molestation versus the lesser included offenses that could be misdemeanors. And were the same 19-year-old to send an email directly to those 13-year-olds with the same images, currently he could not be captured under any, unless he was a 19-year-old basically the transmission, whether it's walking into the room with a magazine or sending the images by email. Currently, the only act that could be captured under the existing law is the act of walking into the room with the magazines, not the act of sending the same images by email directly to those children.
That's right.
Thank you.
Mr. Knox.
Along that,
Yes, you are.
along that same line, is there anything different?
Thank you. Is there anything different in character about this offense because of the fact that it's sent electronically than it would be if I took the same images, pictures, a CD or whatever, I put it in an envelope and I mail it to them? And how do you prosecute that currently, or can you not prosecute that? And if you can't, it probably ought to be included in this because the effect is going to be the same. They're not in the presence. They've done exactly the same thing that they're doing electronically. What's the difference whether it's electronically or it's done through the mail, for instance, or I have a courier take it over there and drop it off?
Well, my goal was to specifically deal with the situation with the webcams because we know that is a real problem that's out there. We know that the internet is the new Wild West for sexual predators. Whether it be communicating it via the mail or carrier pigeons, I agree. I think it all goes to the problem with the physical presence requirement because, like I said, the impact's the same. I didn't try to address that. I tried to narrowly tailor this to the conduct that I think is really a problem and is becoming a greater problem by the day as technology proliferates. But I think it's a fair point.
Yeah, I'm going to ask Mr. Ballard for just as a follow-up. The use of the mail in that context becomes a predicate act for a federal charge,
right.
does it not?
It could very well, right. Yeah, generally we don't get to prosecute the mail fraud of the crimes through the mail. And I don't know what the current mood is with the feds with regard to prosecuting what you just outlined, but it's a real good point.
Well, they're not going to prosecute the offense. They're going to prosecute the offense of using the mails for unlawful purposes and fraud of the mail. So that's a separate offense altogether than what we're talking about here. So they can do that or not do that, but my guess is they're probably not going to be any more interested in prosecuting that than they are in prosecuting a lot of other things. They got enough. They got all they can do to deliver the mail. If they can't deliver the mail, I don't know what kind of a job they're going to do investigating crimes. But my point in this is that you're making the distinction here about the presence because the threshold for this is that the problem is the key to the issue is that it's not occurring in the presence of the person, right. Of the victim, and. And I agree that we should do this, and I'm glad that y'all have addressed it. But my question is, if this is what we're really talking about here is a difference between allowing two different. The character of these offenses is different. It's the difference between being in a room with somebody and doing something to them or in front of them. They have a physical connection to me. It makes a difference how close you are to somebody. If you can't see them because they're so far away, that may make a difference. And so there's a difference in the character of these offenses because what I'm really doing is I'm giving them a depiction or a description of what would otherwise be an offense in the presence. Okay, seems to me like that's a big difference in degree and in the character of the offense. But we're treating it as the same offense under this code section by putting them together and giving them both 5 to 20. And I agree we need to go up, we need to try to get after the internet and whatever. The other concern I have is that I'm not sure that this doesn't, you could do the same thing on a telephone, couldn't you? Couldn't you pick up the phone and call somebody up and that's an audio device. It's not, and it is, I guess it isn't a telephone electronic. I don't know, is it? But anyhow, it seems to me a telephone is an electronic device, broadly speaking, because it goes over the electrical wires and whatever.
Well, and that was exactly the issue that was addressed in Vines. Is looking at the definition of child molestation. That there are 3 ways you can commit child molestation: to a child by committing a lewd act to a child, in the presence of a child, or with a child. And Justice Hines spoke exactly to that point. He said in saying that what the majority in that case was doing was not supported by the plain language of the statute. He said the injury involved here is not simply that a child hears explicit language, as the majority suggests. It's the use of a child victim for a sexual purpose while employing that language that OCGA 16-6-4 protects against, and it's conduct that's prohibited. I mean, it's a policy decision, but that goes to the heart of the case where this problem was created.
And I'm not arguing with you. I'm not saying we don't need to do something like this, and I appreciate y'all making this effort at it. But I think that we need to consider what the effect is on the child, because I don't care about the victim, whether they're being immoral or what. I mean, the perpetrator, I don't care whether they're being immoral for whatever purpose. It makes no difference. I don't think that even ought to be a crime. If you want to do something, that's your business. That's your little party. You can have your own party at your own house if you want to. But what's the issue really is what's happening to the victim, I think. And you've got, I'm not sure that we've got the same thing happening here to the victim. Seems like there's a difference of degree in what you're doing in order to arouse it. Makes a difference on the impact on the child.
And I think that's a policy decision and something that each member of the committee has to evaluate. I would suggest to you that and there's a million cases out there where you don't have to touch a child to commit child molestation. You have to commit a lewd act and now you have to do it physically in the presence of them. But I would suggest to you if an individual induces a child to come in and watch them masturbate as they did in self, and then and another individual induces a child to watch the exact same act over the internet, using the exact same words, I wouldn't necessarily agree that the psychological impact is different between those two acts. The child's witnessing the same act, the same words were used to induce the child to watch that act, and I think drawing a distinction between the two is problematic.
Let Mrs. Cooper jump in, and then we'll come around the horn a final time.
Thank you, Mr. Chairman. I just wonder, the child advocate for the state is here. Would it be proper to ask the child advocate if he had any comments? I'm certainly in favor of Representative Ramey's. Would that be appropriate to ask the child advocate?
Let me do this. If there's a specific question for the author or for Mr. Ballard, that would be great. If in the course of those questions they'd like to defer to Judge Rawlings, that would be fine too. We'll be flexible, sure. Mr. Setzler.
Thank you, Mr. Chairman.
Hold on one second, Mrs. Cooper. Did you have a?
No, I just had some concern over when we did the law last year for.
Can you pull the mic toward you?
When we did the law for Representative Keene, we carved out an area for young people, and I guess I just had some concern about young people will be young people and the boys will be boys and I guess girls too now. I think they're finding girls are just as aggressive in sending what could be considered lewd things over. But I just had some concern about that age group.
If I hear your question correctly, and correct me if I'm wrong, what I'm hearing is a concern on your part between what is the so-called Romeo and Juliet situation where kids or young people within a certain number of years commit certain acts, and how that would be how does this bill treat that situation, if differently at all? Is that what I'm hearing?
That's right. I'm not an attorney, and I'm just trying to look at it, and that's what
sometimes that's the best place to be.
That's my
concern. So don't worry about that.
Thank you, Mr. Chairman.
DA Ballard, if you could go ahead and address that, I think you can.
Romeo and Juliet would still apply. This would be an act of child molestation, so the young, if there's still that close age difference between the victim and the perpetrator, it would be treated differently from the broader difference.
I have one more question.
Yes, ma'am.
Do we ever have, or do y'all ever see in the cases, and this is just lack of knowledge, some child that falls in that Romeo age that you would actually consider a true predator, and so they get off lighter?
I'm not sure I understand the question.
I don't know how to put it. Or who
15 years.
Oh, I'm sure they are, yes.
And then yet, because we had that, they do get a lesser sentence, and it could happen here.
Right. I mean, time, you need the passage of time to know, of course, but by the time this person gets 50, I think the scientific evidence suggests, historical evidence suggests, they're probably going to molest a lot of people.
And they were doing it now. Thank you.
And that sort of touches on Representative Knox's question about the policy decision here about whether we want to treat, whether the danger to the victim is as great over the internet as if they're in the room doing the act to them. And I guess we don't know. We won't know until years pass and we see how these injuries to these victims play out. But I would like for the legislature, if there's going to be an error in that respect, err on the side of caution for these victims.
Thank you.
Yes, ma'am. Mr. Setzler.
Hey, Mr. Chairman. To the author, what I'm hearing you say, and I certainly affirm the intent that we're trying to make sure that someone who is not physically present, who is really trying to commit the crime of child molestation, but is trying to bridge the gap of physical presence by using some electronic device, can still be prosecuted that way. Is that really your intent?
That's a very succinct and good description of what I'm trying to do.
I mean, it seems to me that as I think through this, what we're trying to get to is it shall not be a defense that the person's not present.
That's exactly right. What the Supreme Court made a policy decision, and I think it is not in keeping with what the intention of the legislature was, and it's not in keeping with the plain reading of the statute. I am seeking to eliminate what they did is write a physical presence requirement. That is right now that is an absolute bar to prosecuting somebody for child molestation. If you're not physically present with a child because of the Vines case, you cannot prosecute that person for child molestation.
And Mr. Chairman, and to the witness, I think this committee wants to support that policy intent. I guess the concern is, particularly listening to Chairman Knox's discussion, with respect to telephones, internet. This, as I read line 10, a person commits the offense of child molestation when such person, by means of electronic device, transmits images, and it goes on. We know the language. It seems to be definitive that if you transmit an image with the intent of sexually arousing a person 15 years old or younger, that it triggers child molestation necessarily. And again, I think what we're trying to wrestle with now is that the same as doing that in a person, or the lesser, as it were, acts that would meet the definition as defined here in lines 14, 15, and 16. Will those always trigger child molestation? I think it's the sense of the committee that there are certain cases that wouldn't warrant child molestation, but certainly some would, which is your intent. And how do we craft this so that what we really accomplish is it shall not be a defense that an individual is not physically present?
Well, that goes to the issue of the DA's existing discretion as to what to indict and what not to indict, doesn't it?
It does, and also, if you think about it, what we're really saying is if you do an act with the intent to arouse the sexual desires of a child, you've committed a crime. What's wrong with that? Even regardless of whether you're showing them pictures of topless women or whatever. I mean, I think as a state, we have a policy against trying to arouse the sexual desires of a child.
And I hear that.
Can I add something to that,
Yes, sir.
Just in answering your question? The act itself, the person, your scenario, the person transmitting the topless pictures, that act would be evaluated exactly the same way if that same person walked into the room with those topless pictures and showed them to the child. The acts we're talking about here are not going to be evaluated in terms of triggering child molestation any different than the way child molestation is currently an act that's potentially child molestation is currently evaluated. We're not trying to disturb any case law or disturb any prosecutorial discretion in that regard.
Let me, Mr. Cecil, I want to give Representative Collins a chance.
I'm passing. Thank you, sir.
Mr. Chairman, and my only concern is, and I hear that, and I understand prosecutorial discretion. However, in 2006, when we rightly, as a legislature, took a very strong step forward with strengthening our child molestation laws here in Georgia, and really dealt with sexual predators in, I think, a fairly holistic way. We do have the 5 to 20 year felony treatment for child molestation, which is a very significant felony punishment. You've got the whole sexual registry regimen that's thereby invoked. I suppose I would be more comfortable with this if what we're saying is, for purposes of any person who transmits images, text, audio, electronically, it shall not be a defense that the individual was not present. I think that's what we're trying to accomplish. I'm just concerned by the words I read on the page here is that if someone transmits images via the internet, they've triggered a 5 to 20 year felony. And we can talk about prosecutorial discretion. And I don't say this to impugn prosecutors. I just think we as a General Assembly have an obligation to balance that. And I think a lot of times if these kinds of things, as it plays out, as you well know, if you've triggered these elements, frequently a team of prosecutors can use this 5 to 20 year felony to get folks to plead out of court for a lesser sentence without going to court. And I'm just really concerned the effect this would have would be to catch a much broader array of behavior than we're intending here, and then hold this 5 to 20 year sentence over people's heads. When what we're really trying to accomplish is it shall not be a defense that the individual is not physically present, Mr. Chairman.
All right, let's give him a chance to respond.
I guess we're kind of circling around the same issue over and over again a little bit here, and I appreciate the point of Representative Setzler, but the acts you're concerned about under the existing child molestation, you suggested sending words over the internet. If I walked into a room and handed a piece of paper to a child under the definition of child molestation, you potentially technically could be charged with child molestation. So I believe as currently drafted, we do nothing in terms of disturbing how an act is evaluated in the context of determining whether it's child molestation or not. And I'm not sure that's going to satisfy you, but that's my opinion in terms of how we kind of came out on this from a drafting standpoint.
Mr. Knox.
Back just one more go around on this, if I could. And again, I think we need to try to address this, but I want to be sure we're addressing it, in the most effective way. And I haven't read this decision, but isn't there an offense of enticing a child?
Yes, there is.
Okay. And wouldn't this be covered under that offense?
Well, enticing a child is where you lure a child for the purpose of committing child molestation. Child molestation is where you actually do an act in the presence of a child with the intent of arousing either the perpetrator or the victim. So there's a difference. A lot of conduct could bridge both.
Right.
And I would just simply put, child molestation is child molestation. If the acts we're talking about, whether they're done in the presence of a child in the room or communicated over a webcam, it's child molestation.
And I'd point out
that's why we're trying to address it within the context of the offense of child molestation.
I guess that's what I'm trying to get at. We can divide offenses into their component parts and make them separate offenses so that we only punish the degree of offense that's taken place, and that's kind of what I'm trying to get at. I think one of the reasons that they insisted on physical presence in the code section prior to this, because I believe this was passed, I'm not sure what year this was passed, but I don't think the internet was unknown at the time that code section was crafted.
And it wasn't in the code section. If you read the definition, it's with a child, in the presence of a child, or to a child, the act is committed. And the court read that, ignored the two words "or," and said you have to be physically present.
And I wonder if the court is considering that when we're talking about publishing anything, whatever it is, that we're wandering into the area of constitutional considerations of free speech and so on, and that I think that may have been one of the reasons, at least that should have been if it wasn't, that they took into consideration when they were saying it had to be a physical presence, because you had to have the means to be able to do it, and secondly, whether or not you how broad are you going to apply this to restrict someone sending the materials out, and how many people will be placed in jeopardy even though they didn't intend to send it to that child, for instance. And so, this has been tried over and over again about, what's pornography? Is it, because I published a picture of a nude person, that some people that's pornography, and other people said, no, it's got to be something else. And so, I'm wondering if that isn't the reason they've gone, that they went and made this distinction about being physically present. Another reason that they did.
There was not a one mention of that in the case decision. Any constitutional concerns?
Mr. Levitas.
Mr. Chairman, at the appropriate time, I've got several proposed amendments.
Yes, sir.
The first one.
Do you want to?
Whenever.
Well, you could either give us. You could give us. It's up to you. We could either get an idea right now, digest that. Mr. Franklin, I know, has a question. Then we'll take motions, and then we'll get into that. It's up to you. That'd be fine. I'd be good to go ahead and have that so people can take a look at it as they're multitasking.
The first one is just really a technical correction. I think what we need to do is not have it upon the signature of the governor, but upon signature of the governor, or if it becomes effective without his signature, because otherwise it would not become effective unless he signs it.
I think that's what we have here.
Okay, I thought we had just upon his signature was how I heard it. Okay.
Well, I'm looking at 3707S, correct?
Yes.
Okay.
Mr. Chairman.
This act, Section 2.
Oh, you're right.
Okay.
I'm sorry, Mr. Chairman. You're absolutely right. The other amendment that I have is the venue question that we addressed, and I'm just stealing Representative Lunsford's language from his bill, and it would be a new subsection B that would just say any violation of subsection A of this code section shall be considered to have been committed in any county where such transmission, I guess, or posts were received, where they originated, or in any county where they are received. And we can put that in more formal language, but that's what they did in the other code section. The other change I would have, Mr. Chairman, is to strike the words of any electronic device, and in between by and means, put the words any, so it would read by any means such person posts or transmits, and I would add the posts in front of transmits, posts or transmits images, and then it reads the rest of the way down the line.
On that,
This is lines 14 through 16. So on line 14, after the word by, insert any, strike of through device, before transmits, add the words posts or.
So read it as if it were.
So by any means, such person posts or transmits images or audio of any immoral or indecent act to a child under the age of 16 with the intent to arouse or satisfy the sexual desires of either the child or the person.
So read by any means such person, etc.
Right. Such person posts or transmits, and then etc.
Do we have a concern on the word posts as it goes to the issue of intent?
I do, Mr. Chairman.
I think I do too.
Then I would withdraw that portion of.
I see where you're going. I just think that the posts you're getting into an intent question,
that's fine. Then I would withdraw that part, and as I said, and then I would have the other language regarding venue.
Okay, when we get to that appropriate time, I'm going to ask you to read that slowly again
yes,
for us. Right. Mr. Franklin.
Thank you, Mr. Chairman. Since it seems like what brought this whole thing about was the Vines opinion dealing with presence, would it be even doable just to keep the existing code section but strike the in the presence of?
I don't think so. I don't think we want to. When we went round and round on defining the word presence, and that's for several months, that was the direction I was going. But there was a real concern about disturbing settled case law in the many different acts you can commit to be considered a child molester. I think if you remove the word in the presence of, you may preclude a prosecution for the person that induces the child to come in and watch them do the acts we've been talking about in this self case. I would have a real concern about what that would do to kind of unsettling the apple cart with respect to the body of case law out there defining what acts constitute child molestation.
Okay, and just one other one. If I heard correctly, it was your opinion that the Vines opinion was erroneously adopted.
I think as a matter of both statutory construction, and I'm not here to criticize the Supreme Court. And I don't want to.
Right.
I don't want to do that. But I think they made a policy decision that is not appropriate for the judicial branch of government. I think they came into what should be a decision we should be making right here in these rooms, and they read a requirement into the law that I don't think was ever intended. And that's my opinion.
Because where I'm going with this, which might not specifically address this particular bill, but it's something that's out there that's come up in a subcommittee of this committee already, is this type of legislating by the judicial branch, and yet we do have a constitutional provision that when they do something erroneously, that all lower courts are bound constitutionally to follow it, which is contrary to the to settled common law that precedent is not law, but it is evidence of the law, but it's not law itself.
Well, in my opinion, they got it wrong, but these are some pretty smart folks, and that made this decision, and I certainly wouldn't want to upset the requirement that lower courts follow the precedent of the highest court in the state.
So even though they got it wrong, you would want
they got it wrong
to perpetuate.
Well, they got it wrong in my opinion, and that's why I'm trying to rectify it. I think they engaged in judicial policy making, but there were 5 justices on the Supreme Court that researched this and believed it was supportable. So
we have another issue like that coming up real soon.
Thank you, Mr. Chairman.
Yes, sir, Mr. Franklin. Mr. Hatfield.
Mr. Chairman, Representative Ramsey, the discussion that took place about the proposed language about posting raised a question that I have. A lot of communities now, it's become prevalent that they have these various chat rooms, or they have screens that a lot of people post on. And my question would be, what are the protections in here if someone, in the course of one of these chat rooms, they post some sort of indecent photograph or some sort of indecent text or something, and you've got a child under the age of 16 that comes in contact with that posting.
I think the protections would be no different than if a group of friends were at Starbucks having a chat and committed the same act, showed the same picture to the child. The act would be evaluated the same. I also think there's a requisite intent here when you talk about transmitting the image to the child. But when you talk about a chat room, whether you're chatting with a group of friends in a room and you show them a lewd picture, or you're chatting with a group of people on the internet and you post a picture, that act would be evaluated the same way based on case law as to what is an immoral or indecent act, what's the requisite intent required.
Is it your intent with this bill to include that sort of conduct within the prohibitions of this statute?
I don't think my bill goes to the conduct required to constitute child molestation. My bill goes to communicating an act in a different way than doing it physically present. I don't think my bill speaks to changing what conduct is required to constitute child molestation.
Well, what I'm saying is that I see where you're trying to go, or I know where you were originally trying to go with regard to this Vines case, but my concern is that listening to some of the debate and giving this some further thought, that you may sweep up a whole lot of other behaviors that are not intended, that perhaps you don't intend to include within this sort of conduct. But as far as the intent issue goes, I think that different prosecutors may see that differently, but certainly there are prosecutors out there who could and would attempt to prosecute somebody on the basis of the behavior I've just described.
And I would suggest to you that we could come up with a lot of bizarre scenarios right now under the definition of child molestation that could technically be prosecuted for child molestation, that happened physically in the presence of. That again, it goes to your concern. I don't think.
Well, I'm not trying to. I'm not. I don't think it's a bizarre scenario, and I'll go further.
No, I'm not suggesting that it is, but I am suggesting that what you're describing, a person could be prosecuted technically for child molestation for doing the exact same thing if they're sitting around with a group of friends and shows a lewd picture.
But there's a qualitative difference, because if someone's sitting around in a Starbucks and showing friends that, and a child happens to see something that they're not a party to, factually, I think that's more defensible than if you're in a, you've got some sort of community chat room or something, and a child is a poster on that, and a parent, say a parent finds out and says, well, somebody's posted this lewd text or this lewd photograph, and my child came into contact with it, so you've transmitted that to my child, and you've committed child molestation. I'm just because the different contexts. I think that the factually, you're right. You could argue you could defend that in-person situation, and in my opinion, better than you could the one over the internet. And one other question I want to ask, and I'll wrap it up, Mr. Chairman. But when you say by means of an electronic device, technically, if you had a television that was you had a television show that was broadcasting some sort of sexual material, whether it be HBO, one of these pay services, whatever, and a child is watching that, a child under the age of 16 is watching that, then would that not technically fit within the parameters of this language?
Do you want to address that? I don't think so. I mean, you're transmitting to a child under the age of 18 with the specific intent to arouse the desire of yourself or the child. I don't think putting a television show on.
Well, first of all, you're not transmitting if you're watching TV. Not getting into the intricacies of
the broadcast
of broadcasting and so forth. I mean,
you got the ratings. They're.
And that's the first iteration of this had the word broadcast in there, which we removed for exactly that point. So.
And doesn't that get back to intent as well?
I believe so.
All right, Ms. Abrams, and then we'll wrap it up for these witnesses and see if anybody else would like to testify.
Thank you, Mr. Chairman.
Yes, ma'am.
Mr. Ramsey, you and I have worked very closely on this, and I think we've kind of circled around each time someone's had a new thought. I find it compelling, the concerns raised by Mr. Setzler, Mr. Knox, the language that follows the word transmits, images, text, or audio, to me unsettles what the actual case law refers to, which is an immoral or indecent act. Mm-hmm. It is not about it's about the act. It's about a lewd act, not simply lewd pictures. And at the appropriate time, certainly, if you're comfortable, I think we unsettle the law when we add the transmission word actually captures what you're talking about, which is having an electronic device convey from one person to another person this act.
Right.
And so it would suggest that the language that occurs after the word transmits, that would be images, text, or audio, that language is is further complicating what I think is a fairly straightforward idea, and at the appropriate time and intend to make an amendment to strike that language.
And as you know, in our work on this, our first version of this said had exactly that. We didn't have those words in there. And working with legislative counsel, it was our sense that grammatically, if it said by means of an electronic device, such person transmits an act, grammatically it didn't work. So we had to actually put something that's being transmitted. I
would disagree. I think that the word act has operative meaning based on subsection A as it currently exists. The case law refers to the act. It doesn't refer to how the act is achieved, whether it is a combination of sitting in a room reading a pornographic story or whether it's showing pictures. It refers to the act itself. And the egregious conduct that we're talking about typically is much more active. And I think the more we discuss this, the thought that someone would be on the sex offender list for the rest of their lives for bringing in Sports Illustrated, I find to be deeply problematic. Well, so would like to err on the side of caution.
I agree. If the members of the committee believe grammatically we can do it, the first version I preferred in terms, because our goal was to track as much as possible the existing definition of child molestation.
I mean, Black's Law Dictionary defines transmits to mean send or convey. Mm-hmm. And so if you're conveying, it's going to be, by the very nature of what you described with the webcam, it would be the act that is transmitted. It would be that activity, that act would be transmitted. So you have, I think, the operative, you have the direct object that you need for that verb to make sense.
Well, I would certainly yield to your wordsmithing on that, and I agree. Yeah.
Let me thank Chairman Ramsey and D.A. Ballard for their time. It's been a good conversation. Let me ask, is there anyone else in the audience who'd like to testify on the proposed substitute of House Bill 123 at this time? Hearing none. Chairman Ramsey, we've got a couple of options. We can go through the amendment process right now. We can take a beat, and we are here on Monday morning for two bills that have been previously scheduled at 9:30. We can move that meeting to 9, and we can hold this bill until then, if you'd like to have further conversations, and we can take it up again at 9 a.m. sharp, or to the extent this committee does anything at any sharp time. Or we can proceed now, and I want to give you that option as to what your preference would be, knowing full well that we would take it up again at 9 a.m. on Monday, whatever is your pleasure.
Well, can we? I'd proceed to go forward. I would prefer to go forward now, particularly just to see what amendments. I mean, if we get through the amendment process and we need to have further discussion, I'm just curious to hear what amendments are out there, and I think that would be helpful.
If that works for you, that works for us.
Yes, sir.
There's no other member of the audience who I think wants to testify on 123. That being the case, is there a motion?
Move to pass.
There's a motion to do pass by Ms. Abrams. Is there a second? Second. There's a second by Mr. Levitas. Are there any amendments, Mr. Levitas?
Thank you, Mr. Chairman.
Yes, sir.
There we go. Thanks. My first amendment would be to change, beginning on line 14, by inserting the word any between by and means, striking the words of an electronic device, and continuing with the rest of the language. So it would read, by any means such person transmits images, text, or audio of any immoral or indecent act to a child under the age of 16 years with the intent to arouse or satisfy the sexual desires of the child or the person. I do have...
Is that? I think we'll separate it.
That's fine. That's what I was going to ask you,
yeah.
Is whether you wanted to take them separately.
I think so.
And I believe Ms. Abrams probably has a substitute motion.
By amendment proposed by Mr. Levitas, by any means, on line 14, by any means such person transmits images, etc., with no other changes.
Right.
At this point for this particular amendment.
Right. By any means, and then strikes of an electronic device. That's
okay.
Right.
Ms. Abrams.
I'd like to be recognized for substitute motion.
Yes, ma'am.
I would actually say that we retain the language by means of an electronic device, but strike the words images, text, or audio of on line 14. and I say that for this reason. While I understand Mr. Levitis's intent, I think the importance is the method of conveyance, which is an electronic device. Given the consequences that Mr. Setzler identified for capture under the child molestation law, I believe it is, and to Mr. Knox's concerns about what constitutes child molestation versus lesser included offenses, I think it is an overreach to say that any transmission constitutes child molestation. I think it is. We're trying to capture a very specific set of activities, and so I would say that it should be by electronic device, but it should be transmission of the act. And so my motion would be that we strike the words on line 14, images, text, or audio of.
I'm inclined to consider those separately, because I think you've got those may be. I understand where you're going with that. My sense is that might by any means of an electronic device. You've got the issue of, does it need to be an electronic device? What is an electronic device, to Mr. Lunsford's comments before? And then you get into the separate issue of, okay, what is it that we're talking about? You know, it's the means of transmission, and then it's what's being transmitted. Do you agree with that?
I guess what I'm saying
in terms of how we should consider that?
I think if you consider it in terms of what Mr. Levitis put forward and what I'm putting forward, his language, as I understood it, eliminates the notion of the device but retains the issue of images, text, or audio, which is to say that any way that you transmit it, it should be child molestation. My statement is that we should be, instead of overly expansive, we should be narrowly tailored. And so it is a question of, it's a qualitative question. It may be simply that we vote up or down Mr. Levitis' amendment and then we do mine.
I think that would be the cleanest thing to do.
Can I ask a question of
Yes, sir.
the substitute amendment? This is a genuine question. What happens if the offender takes lewd photos of him or herself and then posts them? Literally, it's not an electronic device, but it's done for the intent of arousing the sexual desires, knowing that kid's going to come to his bedroom or someplace where they're going to see him. That's not an electronic device, but I think we would agree that would constitute child molestation, except that you have the presence requirement would be the only way now that would capture that. But Representative Ramsey's number 2, is that a subdivision? What is that? Paragraph 2 would capture that kind of behavior, and that's why. And I think Representative Lunsford's point was we just don't know what the means of transmission or communication are going to be, and to limit it to electronic may be overly restricting. And I agree with you, we have to have that balance. But I think if we limit it to electronic device, we're not accounting for behavior like that.
My response would be I don't think that posting a lewd photograph should constitute an act that's captured by this language.
Okay.
I think that's fundamentally the difference.
And I think that goes to Representative Gold's point. We should just vote up or down
Absolutely.
on it, and then.
I would like to take those separately. I think there are two different issues, and generally it will obviously be recognized at the appropriate time. I've got to move for an amendment by Mr. Levitis of the following on line 14 of the substitute House Bill 123 LC 293707S. On line 14, by any means such person transmits images, text, or audio, and so on. Any further discussion on the amendment? Mr. Franklin.
This would be in the form of a parliamentary inquiry, because I believe that if we adopt Representative Levitis's amendment, amending line 14, then Representative Abrams' amendment amending line 14 would be out of order, because we can only amend a line once.
Well, I don't know if we could or not, but why don't we just consider it a substitute motion and do Representative Abrams first and then mine? I mean, it doesn't matter to me what the procedure is.
I mean, procedurally, I think that the most intellectually honest thing to do would be to go ahead and vote on the Levitis amendment and then vote on the Abrams amendment. I have no strong feelings about that. I think things ought to be considered, issues ought to be considered individually on their own merits.
As long as we would be able to vote on both.
Absolutely,
without
that's
one
the intent.
Okay.
That's absolutely the intent.
I would rather that we weren't
I'd rather have
procedurally
that.
locking.
No, we're not
locking that
procedurally
up.
locked into that. I'd rather be a little more expansive on that and have people have their day. So, Mr. Setzler, now let's go ahead and vote on the amendment.
Thank you, Mr. Chairman. To the author of the amendment, Representative Levitis, am I to understand that the intent of your amendment is that if someone posts not via electronic device. It could be a physical posting of an image. It could be a physical presentation of text with an intent to arouse someone 15 years old or younger, that would constitute child molestation?
Absolutely. If there was somebody who said, and I'm not going to use the words of mixed company, but if he said, I want you to come meet me to do X, Y, and Z, absolutely I would want that captured. And let me be clear, if there's that language out there, if mine is too broad that it would cover that swimsuit model issue that I'm now very interested in looking at, I don't want to capture that. But that kind of, whether it's language or video, absolutely. If it's an indecent or immoral act, I would want that captured, text or video.
And I asked that question because it gets back to something Chairman Knox shared a moment ago. You know, the character of the crime. Clearly, it's criminal behavior, and we look at where within the code we recognize it. But under our current framework, to which we put a 5 to 20 year felony and lifetime enrollment in the sexual offender registry, is the character of performing an act or touching a person 15 years old or younger, child, is the character of performing an act or touching a child the same as posting text that was intended to arouse a child or posting a photo? I mean, I think that's what the committee's got to decide: is the essence of those two crimes the same, or are those fundamentally
and that is inherently a policy issue. Let's go ahead and have this vote on the Levitas amendment.
Can I speak to the Levitas amendment, or is that out of order?
It would not be out of order. Let me just ask you to keep it brief, because Mr. Talton has been sitting here for quite a while, and I've taken notice of that, and he's a saint. So
yes, sir.
let's.
Yes, sir. Yes, sir.
No, he is. He's been very patient, and I appreciate that personally.
I very much appreciate my good friend Mr. Levitas and where he's going with this, but I'm a little concerned. We really worked at narrowly tailoring this to get at a conduct and a means of conveyance that we know is a problem, and I think your amendment, Representative Levitas, your amendment may send us in a direction or raise some questions that we were trying to avoid raising.
Mr. Chairman, I'd like to withdraw my amendment.
Very well. Mr. Levitas, you had a second amendment.
Yes, sir. And I actually, in hindsight, think it needs to be restated. I originally stated it as a subsection B, and counsel helped me here. I believe actually it should come in the same sentence as paragraph 2, because it wouldn't make sense in terms of paragraph 1. So what I would say is at the end of the line, add the following. The end of line 16, add the following. Any violation of subsection A2 of this code section shall be considered to have been committed in any county where such act originated, or in any county where such transmission was viewed, heard, or otherwise witnessed.
All right, so that's the venue provision. No,
I know. I'm trying to just restate it. For folks.
And you're taking that from the Lunsford bill from last year?
This is from 395, right? It
okay.
is.
Let's just real slow, please.
Okay. I can't, because I've only got the. I pulled it up through the legislative search. I can try and do that. I learn something every day from you, Ms. Travis. This is.
You don't need a venue provision.
This is Article 2 of Chapter 11 of Title 16, 1611-39.2, 1611-39.2. And this is D, I believe, subsection D of that code section. It's not the exact language. I've added language to it, but that's the essence of the model. And when council's ready, I can read my additional language. All right, my language would be: any violation of subsection A2 of this code section shall be considered to have been committed in any county where such act originated, or in any county where such transmission was viewed, heard, or otherwise witnessed.
The very last part of it again.
Yes, sir. Yes, ma'am. I'm sorry.
any county where the
where such transmission was viewed, heard, or otherwise witnessed.
viewed, witnessed, or viewed.
Viewed, heard, or otherwise witnessed. And I don't know that we need the or otherwise witnessed. I just didn't want to leave anything out by saying just viewed or heard. I don't know that there's another way to witness that, but just wanted to make sure we were covering everything.
Chairman Ramsey, let me, while Ms. Travis is looking at that, you would agree that that the venue provision would be appropriate?
Yeah, as long as everybody's happy with the folks that are going to be
and
applying this.
And that's exactly why I'm asking the question. My sense of it is it's an important provision to put in. I appreciate Representative Levitas coming forward with it. The ability to go ahead and look at that amendment closely in the context of the specialness of this particular code section, my comfort level would be that we go ahead and have that printed out, take a look at it, be collectively comfortable with it, along with any other amendments that may come, so we could go ahead and take a look at it in total on Monday. I think we get into dangerous amendment on the fly on technical issues is one thing. When you're getting into venue and other important aspects, that gets me concerned, and I'd appreciate your indulgence if we could hold that until 9 o'clock Monday.
My only, and I'm fine with that. My only concern is a personal scheduling matter. I was going to be practicing law on Monday morning. I had client appointments, but I think I could probably get those moved around and get back down here.
So the gentleman is under the impression that he can actually make a living during the session.
Well,
it's only the second year.
Feeding the family's overrated anyway.
Let me
be happy to come back down here and spend some more time with y'all.
Point well taken.
Mr. Chairman.
Let me suggest that we'll work around your schedule, and whatever your time frame is fine. I do think the venue provision is important.
I agree.
Amendment on the fly does get me nervous sometimes in the absence of technical issues. I know there are other proposed amendments. Any other proposed amendments on this extremely important bill, I'd ask for to be printed so that Mrs. Harden can have copies for us. I hope that's a reasonable request, and I appreciate your indulgence on that.
Sir,
but this is too important to have something on the fly.
Yes, sir.
I hope you. Thank you.
Mr. Chairman.
I do appreciate it. Yes, ma'am.
On the issue of venue, I would also encourage you all to look at the venue provision that's in 1612-100.2, which is the computer pornography, which talks specifically about inside and outside of the state, and I think offers better language than the disorderly conduct one.
And that's why we have this process, to make sure we get it right. So I appreciate it. We're not going to obviously go through the exercise again. We'll have that language in front of us from all parties, and you'll be able to know what's going to happen, and we should be able to expedite that whenever that does occur, according to the gentleman's schedule, pretty expeditiously.
I will be here on Monday morning.
If the gentleman would like, we could go ahead and have we'll have. My sense, members of the committee, is that we're getting into that time, and I gave you fair warning at the beginning of the session. We were going to have periodic meetings. We try to spread it out as much as we could in order to go ahead and not have extended meeting-a-thons, as I call them, which is only slightly best than a lawyer-a-thon. That being said, I think we're getting into that territory where we're going to be meeting about 3 or 4 times a week, and I just want to give you all fair warning on that so that we can go in and get our work done, with the hope being that we're not going to get right up on day 30 with something that's a priority item. That's my goal. That's why you're going to see 3 or 4 times a week for the next couple weeks. If the gentleman likes, just for purposes of consideration, we could go ahead and schedule this for a Tuesday morning, if you'd like.
That would.
Just think about that and let me know.
Could I call the committee this afternoon and see what the. I'd really like to try to get down here Monday morning. When I get to my office this afternoon, I'd love to look at it. And is that possible?
We can do it Monday morning. We can do
it
it Tuesday morning.
Okay.
It's whatever works for you. I think we need to be flexible on that. And I appreciate it, Mr. Levitas.
I have a point of inquiry.
Sure.
Given that counsel is almost always right whenever I have she has an alternative opinion, would I be permitted to either amend the language or somehow substitute it if Ms. Travis has better language. I've already proposed the amendment. It's on the floor, but if there's better language out there,
Gentleman,
I'd like to
just go ahead and withdraw his amendment right now, and then we'll go ahead and refresh one.
I withdraw my amendment. Thank you, Mr. Chairman.
Sounds good. All right, we'll go ahead and postpone until Monday or Tuesday the substitute to House Bill 23. I think that's the most productive route we could take. And thank you for the I mean, this is an important bill, and this is the brave new world, for better or for worse.
Thank you, Mr. Chairman and
thank
members.
You. Representative Talton, thank you again for your patience. Please.
Thank you, Mr. Chairman, and members of the committee.
Thank you, sir.
147, and I want to...
Hold on, Mr. Talton, if you don't mind, if we could just get a little bit of order, and maybe a closed door would help. Okay, great.
Okay, 147. I would first like to start off thanking the committee by being patient too and working with me with this, and so many people who've been involved with this. I would like to start off by asking you, would it be permissible for the council, which a lot of this language
yes, sir.
was taken up this
yes,
morning.
Yes, sir. However you'd like to approach it.
And would like for her to read what we have come up with.
On page 2, line 27, at the end of this, at the end of the line there, add the following words: by the clerk of court in which the bond forfeiture occurred.
I'm sorry, that's after mail. What line is that again?
Line 27, after the word served, by the clerk of court in which the bond forfeiture occurred. The problem with this language was that while notice was, it says it's to be served, it doesn't put an obligation on anyone to do it. And that's been an ongoing problem, apparently, that some clerks have been doing it and some clerks haven't. So we're putting an affirmative obligation on the clerks. And there's enough language in Chapter 6 of Title 15 that if we provide it by law, that the clerk would then be obligated to do this.
Is that the only change to 352S?
Yes, sir.
I had just a quick question about notice.
No, sir, actually, the effective date as well.
Okay, let me ask you this question first, if I could. Looking at page 2, line 29, really that sentence up above, starting at line 27, notice of the execution hearing shall be served within 10 days of such failure to appear by certified mail or by electronic means in Code Section 17.650. This goes to a conversation you and I had earlier, and I just want to make sure that we're fortified that is provided for in 17.650 somewhere that I'm not.
Yeah, it's the new language on page 1 of the bill.
Okay.
It's part of the link that was the problem. 17.650 in Section 1 of your bill requires a bondsman now to give the clerk their email addresses.
I'm sorry. Yeah.
And so you have the bondsman giving the email address to the clerk, but then you never had the clerk required to transmit by email until we added that new language. So we're good now.
Looking at the possibility of what if an email address doesn't exist? Just what if?
Well, it says by certified mail or by electronic means.
So do we need to entertain the language of if an email? I'm looking at page 1, line 16, complete address, telephone number, and email address, if any. Only because if they're requiring, they go ahead and communicate an email address. If on the extreme off chance they don't have an email address, then we're giving them a mandate to do something that they're not physically able to do if they don't have one. Just thinking out loud dangerously.
Yeah, I really have no idea about the bondsmen's. I would hope that they would have email addresses.
I would hope so too, but depending on the jurisdiction, I've been told by local officials in some parts of our state that they don't have the ability to electronically file campaign disclosures.
Well, the only difficulty I'm with there now is if the bondsman has to give all this information to the clerk, and then the clerk has to send it out by either certified mail or electronic. I guess the clerk is going to have to know bondsman A only does mail, bondsman B you can do email. Clerk's going to have to keep up with that.
Is there a representative of the Clerks Association? I saw Mike. There's Mike.
That's a good question. Every clerk in the state has email.
Sure.
I can answer that question. We would generally like this addition of this provision to allow us to notify via email. Currently they're not doing it that way. And by the way, Ms. Travis's amendment, I think clerks believe they are covered by this now.
Okay.
I mean, so adding by the clerk is fine. I don't know if your question is, do the bonds companies, I would think.
It's really more a requirement for the bonds companies to supply an email address if, in fact, they don't have an email address. Of course, if they don't have an email address and there's an or, then it can be. But again, this is not for you. I don't think this is for the bondsman.
I would very much like the email address to stay in. I would also very much like bonding companies. I don't know if there's an implicit requirement by this language that they have an email, but it would seem to me if they want to be notified in a timely way, that they're going to try and work as best they can to make that possible. And this doesn't seem to be a very high hurdle to obtain an email address in the 21st century.
I don't disagree. I'm just looking for little problems to help Mr. Talton on, in his process, and really I think it goes to the bondsman who I think I'm looking at their representative right now in terms of it does mandate an email address, and I'm assuming everybody has an email address.
Yeah, without speaking to the association, I'm sure we don't capture every bondsman in the association, so they're not all members.
Mm-hmm.
All of our members have email addresses. I'm certain that we would not be in opposition to that.
Okay, and I think in consideration of the fact that the bondsmen are being fortified by this bill, ultimately that the requirement of an email address may not be too onerous. Is that a fair assumption? Okay, I just wanted to ask that question. Questions? 1, 2, 3. Ms. Benfield.
Thanks. I do have just a comment. I'm wondering if the filing requirements for the Secretary of State's office or for a business license already require that you maintain an email address. I mean, it may already be. I don't know the answer to that. But just one comment on the email address. I think the clerks will probably be inclined to use that provision more than the certified mail because of cost, and it's a lot more efficient. But there's no return receipt requested. And I know it's pretty easy to have the email where you can click and acknowledge that it's been received. And I'm wondering if that would be, if it would help to add that into, I don't know the exact language, how you would capture that, but by email with reply confirmed.
If I'm not mistaken, I see your point. Ultimately, if there was ever an issue, my sense is that information technology within the clerk's office of Cobb County, for instance, could go into sent items and retain it. We sent this on X date. They go to sent items, assuming they can get that in their archive, which I'm sure they can. They should be able to.
Representative Abrams is telling me not every email software program provides the return receipt. Okay. All right, we don't want to create another hurdle. The other, just a grammatical point, and this is a moment when I miss Representative Max Davis, who served as our grammarian for many years. Can we end a sentence in a proposition? Such 10-day notice shall be strictly adhered to. Should we say such 10-day notice shall be adhered to strictly, period?
That's correct English.
Isn't that correct English? Max Davis, are you listening?
In my opinion, that is the more grammatically correct way of phrasing that.
And a split infinitive.
Yep.
So.
Sitting on his cloud, watching you, Stephanie.
Yeah, and Miss Abrams here.
We'll consider that in the. Well, we'll get to that. Any other questions for the author, Mr. Knox?
No, I'm sorry.
Oh. Hearing none, thank you, Mr. Talton.
Thank
And-
you very much.
And we'll go ahead and make that amendment at the appropriate time. I'm going to mispronounce this, and I apologize. Mr. Terry Janone? Okay. Very well. Any questions for Mr. Janone with the Bail Bonds Association? Seeing none. Thank you, sir. Judge Randall? You sure? It's good to have you here, and thank you for taking the time to come up and assist us with this issue. Are there any other parties that would wish to testify on House Bill 147 LC 210352S? Seeing none, it's back with the committee. Is there a motion? Move to pass by Mr. Franklin. Second by Mr. Knox. Are there any amendments? Any amendments?
Just the friendly amendment. Such 10-day notice shall be adhered to strictly, period, on line 32.
Let me look over to Ms. Travis and see if she's... Okay, I just want to make sure you've got that. And we also need to go ahead and... Hold on one second. Ms. Travis has the amendment from Ms. Benfield. Is there any objection to the amendment? Hearing none, the amendment's adopted. Ms. Travis, I know there was the amendment that you spoke to in the beginning of the meeting, and that's on line 27. Notice of the execution hearing shall be served by the clerk of court. I'll say it again, page 2 on line 27, the sentence beginning with the word notice. Notice of the execution hearing shall be served by the clerk of court in which the bond forfeiture occurred, and then jumping to line 28, within 10 days. Within 10 days. Wait a second. Would you read that back for me? Make sure I'm... Notice of the execution hearing shall be served by the clerk of court in which the bond forfeiture occurred within 10 days of such failure.
The failure to appear is from the first line.
Do us a favor and read that amendment that you posed earlier, just to make sure, because that's not really flowing to me, and maybe I'm missing something.
The execution hearing shall be served by the clerk of court in which the bond forfeiture occurred within 10 days of such failure to appear by certified mail or by electronic means, as provided in subsection 17-6-50, the surety at the
I see. Thank you. Any discussion on that amendment? Is there any objection to the amendment? Hearing none, the amendment is adopted. Are there any further amendments? Ms. Travis? Oh, I'm sorry.
And actually, there's two section 2s on 135. That's going to become section 4. Your new section 3 will be on the governor's signature, or if he doesn't sign.
Is there any objection? The amendment is on the effective date of legislation on governor's signature or upon its becoming law without his signature. Any discussion on that amendment? Any objection to the amendment? Hearing none, the amendment is adopted. Are there any further amendments? Hearing none. Any further discussion? There's a motion and a second. All in favor of passage of House Bill 147 by substitute 0352S as amended? By substitute as amended. All in favor say aye. Aye. Opposed? The ayes have it and the motion is adopted. Thank you, Representative Talton. We will meet again, members of the committee. We do have a meeting on 9:30. Excuse me, 9 o'clock. 9 o'clock. It was 9:30. It's going to be 9 o'clock on Monday morning to finish up House Bill 123, Chairman Ramsey's bill. We then have two bills that will be for hearing only. Again, that is hearing only. The two bills that have previously been scheduled. It is likely we will meet a few more times next week. We're going to go ahead and try to set out those agendas as soon as possible, maybe even today, so that members know exactly what's coming and when. I'd also, one last thing, there's in your folder, there's an event at the bottom of one of your pages on the agenda for today. If you have not responded, this is a state bar event. I would actively encourage you, if at all possible, to attend that state bar event. The state bar is a tremendous support mechanism for this committee, and if you can, it'd be great to show our appreciation for their involvement. Again, if you can, schedules being what they are. Is there any further business? from any member. Thank you for coming. We're adjourned.